Hello, everybody, and welcome to History/Law Bite number 179, dated February 9th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled McLaurin versus Oklahoma State Regents, 339 U.S. 637, 1950. This case, like so many others of the era, was one of a long line of suits that challenged racial segregation in higher education, beginning with the landmark decision of Gaines versus Canada in 1938. In McLaurin versus Oklahoma State Regents, we see the plaintiff, Mr. George McLaurin, who already was an established man, applying to the University of Oklahoma to pursue his doctorate. All right, very prestigious degree, of course, both now and then. Okay. However, the school refused admission to him because of his race, being an African American. So he sued in the U.S. District Court for admission to the school, as the state of Oklahoma obviously was in violation of the Constitution, the 14th Amendment specifically, for not providing him with access to the school, all right, as it had done for whites and had been essentially required to do via a previous case in 1948. So, of course, as in accordance with the law, the U.S. District Court required and declared that Mr. McLaurin's constitutional rights had been violated, okay? And essentially, he was entitled to attend the University of Oklahoma to pursue his doctorate. So that being said, the U.S. District Court, however, in declaring that his rights had been violated, didn't issue any injunctive relief. In other words, you must admit him, okay? The court assumed, perhaps logically, perhaps not, that the university would simply comply as, the law had been declared, and that was that. As such, the University of Oklahoma did admit Mr. McLaurin. However, once there, he was entirely segregated from the rest of the student body. He was required to sit away from the white students when attending classes. They made him sit in a separate area of the cafeteria. He had his own place in the library, and this is certainly not the way to encourage, fluid discussion and the ability to actively compete with other students, all right, if you're totally separate from them at all times, okay? And, Mr. McLaurin, offended certainly by this treatment and was not going to take it lying down. So, once again, he filed suit in the U.S. District Court, to be treated in the same form as, the white students at the school. His petition was obviously denied. So he took appeal to the Supreme Court of the United States, which had addressed this issue essentially before in the case of Sipule versus Board of Regents for the University of Oklahoma, 1948, which is covered in a separate video. And the question, and obviously issue, presented to the justices was whether or not Mr. McLaurin's treatment was truly equal, in spite of being admitted to the university, him being kept separate from the other students and totally distanced for absolutely no reason on account of his race. Was Mr. McLaurin's treatment at the university solely differential treatment at the university solely on account of his race constitutional? And in a unanimous decision delivered on June 5th, 1950, authored by Chief Justice Frederick Vinson, the court ruled that it was absolutely unconstitutional that by the way the university was treating Mr. McLaurin. Indeed, the Supreme Court held in this case that treating students differently at public institutions of higher learning solely on account of their race violated their 14th Amendment right to equal protection of the laws. And indeed, the practice was ruled unconstitutional. All right? And because of the court's decision, the restrictions against Mr. McLaurin were subsequently removed. So the great essence from this case was that public institutions of higher learning could no longer treat students differently solely on account of their race. In doing so, the schools violated the students' 14th Amendment right to equal protection of the laws as guaranteed by the U.S. Constitution. Thus, it became illegal for public institutions of higher learning to treat students differently solely on account of their race. This was in violation of the 14th Amendment's Equal Protection Clause in the U.S. Constitution. So this decision, along with a very similar case, Sweat versus Painter, which is covered in a separate video, also decided, all right, in very same day and year. These two cases, this case and Sweat, effectively brought an end to the separate but equal doctrine established by Plessy versus Ferguson in public institutions of higher education, thus graduate schools and professional schools, all right? Under this decision, as well as, like I said, Sweat versus Painter, graduate schools and other professional schools could no longer legally treat minority students differently solely on account of their race, all right, which had been the common practice. Thus, these decisions forced public institutions of higher learning to treat all of their student body in the same cohesive format, all right? Their race could no longer be used as an exclusive method to treat them differently, all right? So that, ladies and gentlemen, is McLaurin versus Oklahoma State Regents. All right? If you have any questions or controversies, leave them down below and I'll be happy to answer them. All right? Thank you so much for listening to this video. I hope you learned a thing or two from it. If you have not subscribed to my YouTube channel, please just hit that little red subscribe button and that little bell right there, and we will be in business. Again, thank you so much for listening to this video. Above all, hope you enjoyed it and learned something. Take care, stay safe out there, and I'll talk to you at the next bite. Peace.